Chartered Bank versus Ople, August 28, 1985. This is a petition for certiorari by the Chartered Bank Employees Association against Honorable BLAS F. Ople in his capacity as the Incumbent Secretary of Labor and the Chartered Bank, seeking to annul the decision of the Respondent Secretary, which denied the petitioner's claim for holiday pay and its claim for premium and overtime pay differentials. The petitioner claims that the respondent Minister of Labor acted contrary to law and jurisprudence and with grave abuse of discretion in promulgating Section 2, Rule 4, Book 3 of the Integrated Rules and in issuing Policy Instruction Number 9, both referring to holidays with pay. On May 20, 1975, the Chartered Bank Employees Association, in representation of its monthly paid employees, instituted a complaint with the Regional Office Number 4, Department of Labor, against private respondent Chartered Bank for the payment of 10 unworked legal holidays as well as for premium and overtime differentials for worked legal holidays from November 1, 1974. The memorandum of the respondent summarizes the admitted and/or undisputed facts as follows. The workforce of Respondent Bank consists of 149 regular employees, all of whom are paid by the month. Under their existing collective bargaining agreement, said monthly paid employees are paid for overtime work as follows. The basic work week for all employees excepting security guards, who by virtue of the nature of their work are required to be at their post for 365 days per year, shall be 40 hours based on 5 8 hours days, Monday to Friday. Time and a quarter hourly rate shall be paid for authorized work performed in excess of 8 hours from Monday through Friday and for any hour of work performed on Saturdays subject to Section 5 hereof. Time and a half hourly rate shall be paid for authorized work performed on Sundays, legal, and special holidays. And this is Section 5 that provides the provisions of Section 1 above, notwithstanding the bank, may revert to the 6 days work week to include Saturday for a 4-hour day in the event the central bank should require commercial banks to open for business on Saturday. In computing overtime pay and premium pay for work done during regular holidays, the divisor used in arriving at the daily rate of pay is 251 days, although formerly the divisor used was 303 days. And this was when the respondent bank was still operating on a 6-day work week basis. However, for purposes of computing deductions corresponding to absences without pay, the divisor used is 365 days. All regular monthly paid employees of Respondent Bank are receiving salaries way beyond the statutory or minimum rates and are among the highest paid employees in the banking industry. The salaries of Respondent Bank's monthly paid employees suffer no deduction for holidays occurring within the month. On the basis of the foregoing facts, both the arbitrator and the National Labor Relations Commission ruled in favor of the petitioners, ordering the respondent bank to pay its monthly paid employees holiday pay for the 10 legal holidays effective November 1, 1974, and to pay premium or overtime pay differentials to all employees who render work during said legal holidays. On appeal, the Minister of Labor set aside the decision of the NLRC and dismissed the petitioner's claim for lack of merit, basing its decision on Section 2, Rule 4, Book 3 of the Integrated Rules and the Policy Instruction Number 9, which respectively provide that the status of employees paid by the month, that employees who are uniformly paid by the month, irrespective of the number of working days therein, with a salary of not less than the statutory or established minimum wage, shall be presumed to be paid for all days in the month, whether worked or not. This is the copy of the Policy Instruction Number 9 issued by the Secretary of Labor to all regional directors. Now, the issues discussed are the following. 1. Did the Secretary of Labor err and act contrary to law in promulgating Section 2, Rule 4, Book 3 of the Integrated Rules and the Policy Instruction Number 9? Number 2. Did the respondent Secretary of Labor abuse his discretion and act contrary to law in applying Section 2, Rule 4 of the Integrated Rules and Policy Instruction Number 9 above stated to private respondents' monthly paid employees? And three, did the respondent Secretary of Labor, in not giving due credence to the respondent bank's practice of paying its employees base pay of 100% and premium pay of 50% for work done during legal holidays, act contrary to law, and abuse his discretion in denying the claim of petitioners for unworked holidays and premium and overtime pay differentials for worked holidays? The ruling of the Supreme Court held that this case is similar with Insular Bank of Asia and America Employees Union versus Inchong. The Section 2, Rule 4, Book 3 of the Integrated Rules and Policy Instruction Number 9 are contrary to the provisions of the Labor Code and therefore invalid. It is elementary in the rules of statutory construction that when the language of the law is clear and unequivocal, the law must be taken to mean exactly what it says. In the case at bar, the provisions of the Labor Code on the entitlement to the benefits of holiday pay are clear and explicit. It provides for both the coverage of and exclusion from the benefit. In Policy Instruction Number 9, the then Secretary of Labor went as far as to categorically state that the benefit is principally intended for daily paid employees, when the law clearly states that every worker shall be paid their regular holiday pay. Obviously, the Secretary of Labor had exceeded his statutory authority granted by the Article 5 of the Labor Code, authorizing him to promulgate such instructions. Now, this is a flagrant violation of the mandatory directive of Article 4 of the Labor Code, which states that all doubts in the implementation and interpretation of the provisions of this code, including its implementing rules and regulations, shall be resolved in favor of labor. Moreover, it shall always be presumed that the legislature intended to enact a valid and permanent statute, which would have the most beneficial effect that its language permits. Obviously, the Secretary of Labor had exceeded his statutory authority granted by Article 5 of the Labor Code, authorizing him to promulgate the necessary implementing rules and regulations. Now, the question Section 2, Rule 4, Book 3 of the Integrated Rules and the Secretary's Policy Instruction Number 9 add another excluded group, namely employees who are uniformly paid by the month. While the additional exclusion is only in the form of a presumption that all monthly paid employees have already been paid holiday pay, it constitutes a taking away or a deprivation which must be in the law if it is to be valid. An administrative interpretation which diminishes the benefits of labor more than what the statute delimits or withholds is obviously ultra vires. The situation is modeled somewhat by the fact that in computing the employee's absence from work, the respondent uses 365 as divisor. Any slight doubts, however, must be resolved in favor of the workers. This is in keeping with the constitutional mandate of promoting social justice and affording protection to labor, as provided by Section 6 and 9 of the Article 2 of the Constitution. And lastly, when the law provides benefits for employees in all establishments and undertakings, whether for profit or not, and lists specifically the employees not entitled to those benefits, the administrative agency implementing that law cannot exclude certain employees from its coverage simply because they are paid by the month or because they are already highly paid. The remedy lies in a clear redrafting of the collective bargaining agreement with a statement that monthly pay already includes holiday pay or an amendment of the law to that effect, but not an administrative rule or a policy instruction. So, on September 7, 1976, the Supreme Court held that the September 7, 1976 order of the public respondent is hereby reversed and set aside. The March 24, 1976 decision of the National Labor Relations Commission, which affirmed the October 30, 1975 resolution of the labor arbiter, but deleted interest payments is reinstated.